Are you looking to make a change in your child's life? Maybe you want them to play a certain sport, or perhaps they need to have some sort of counseling or some other service, and the child's other parent is just not cooperating with you and they won't agree, and you're wondering what in the world you can do about this? Well, my name is Patrick Slaughter. I'm a family law attorney with LaFevor and Slaughter, and I'd like to help you with that. It's not uncommon for parents to run into disagreement when they've split up and they're trying to raise and co-parent their children. The parenting plan does address situations exactly like this. For instance, in the day-to-day decision-making section of the plan, which I believe is under Section A, still right before it goes to Section B, major decisions. If you have your child and you're trying, in your care and you're trying to decide, some minor things to do with the child, you certainly have the authority to make those decisions. If the child needs to stay out of school because the child is sick, you can make that decision. You don't have to necessarily consult with the child's other parent. It's probably a good idea to let them know that you're keeping them homesick, but you can certainly do that if it's during your co-parenting time. You run into bigger problems, though, when it's a major decision, and the major decisions are defined in Section B of the parenting plan. There's a particular section that deals with whether the mother has the decision-making authority, the father has the decision-making authority, or it's a joint decision-making authority, which is probably the most common option that we see. Those decision-making categories are divided into educational decisions, non-emergency healthcare decisions, religious upbringing decisions, and of course, extracurricular activities decisions. If one parent has been chosen to be the authority by having the sole decision-making authority on that particular subject, then what they say pretty much goes. However, most of the time, a lot of these decision-making categories are controlled by joint decision-making authority. And what that means is the status quo is maintained. If one parent wants to change that status quo, then they have to get the other parent to agree. If that parent doesn't agree, then the status quo is maintained and things don't change. So what does that mean? If I believe that little Johnny needs braces, and I want little Johnny to have braces, but the other parent doesn't want little Johnny to have braces, well, we're at a loggerjam. I will tell you, though, that that's usually the basis where someone will file a custody modification action, go in front of the judge, and if a judge hears you don't want your son or daughter to have braces, but the dentist says they should, it's pretty much guaranteed that the child's going to end up getting braces and you're going to pay for it, and judges don't like that. But what I would tell you is if there's a decision, maybe it's about playing football. Maybe dad wants the child to play football and mother's against it, worried the child's going to get hurt. Well, that's not an uncommon thing, and if there's joint decision-making authority and the child wasn't playing football before when the parenting plan was created, if the child's going to start playing football, both parents are going to have to agree. But if there is a disagreement, you can't work out that disagreement, you have the right under the parenting plan to demand mediation. You can send a certified letter to the opposing parent and say, hey, we're going to have to go in front of a mediator. We're going to talk about this. And if we can't work this out, then I may have to file an action to modify the parenting plan. Now, of course, this is no easy endeavor, and this entails spending lots and lots of money. So you better make sure that this is a decision that you really care an awful lot about. But if you do, there is certainly a process by which you can go through to change the parenting plan to allow the child to do something different than what has been done before. It might help, depending on what the decision is or what the change is, to speak with a family law attorney with plenty of experience that can give you guidance as to whether or not you should pursue this course of action, how to go about it, what the cost may be. If you'd like somebody to look at your circumstances and give you an opinion, pick up the phone, give us a call. We'd be happy to look at your situation and give you sort of our idea of what a good course of action for you to pursue might be. In the meantime, I would urge you, talk to the other parent, try to work it out if you can. Going to the court should always be your last option, but if it's always available, the courthouse doors are always open to you if necessary.